I think for purposes of the opening statement, I don't think that's really a problem, right? For the opening statement, it's very good just to listen. This is the evidence you're gonna listen to. We're gonna present it, and it looks, frankly, it was very powerful. I'm very interested to see what the defense opening is. But I don't think that's a problem because I think they'll try to later on when they get to jury instructions, they'll kind of get to that, and also you kind of, if there is a problem, maybe in hindsight you could fix it through closing.
I do not want to be walking in there without having knowledge of the motive, but motive usually goes to a purposeful or intentional act, not a reckless act. So I don't know. If I was a prosecutor, I would like a little bit more. Of course, there may be more. We just don't know. But what about you?
Yeah, I totally agree with you. It's always best to have some type of semblance of a motive that you can argue. But I think the nature of this crime, at least with the elements that you really don't need to go there, kind of lends to the story that he's making, which is like, listen, there's one guy, one bullet, there are bullets between the two. He's painting this picture as like it can't be anybody else but the person that's in the chair that I'm pointing to. And I think just for purposes of the opening, I think it's really, really powerful. And I completely agree with you. You want a sense of motive, but if you don't need one, and you're correct in that, you're kind of ahead, I think. But I think the evidence is going to probably put a motive in people's heads anyway. The guy sounds, the defendant sounds kind of like he was disturbed, and also you got this this pastor. So I think all the boxes that need to be ticked for purposes of the prosecution as far as inuring themselves to the juries, I think they're hitting it, at least at first blush.